Good morning, friends. This is my 198th video, and it will be again covering an issue of a property which was an agriculture land in Agra cantonment. Now, this was about 25 bighas of land claimed to be owned by some Ibrahim Uddin. So he filed a suit in the lower court number 442 in 1995, and the civil judge Agra, who passed an order on 25th July 1995, where this owner was seeking a declaration of being the owner of this property, which was within the boundary pillars of the Agra cantonment. And as per the GLR, this property was given a status or a classification of B4 lands. Now, what is the suit I would like to discuss, because the suit went from lower court to session, then to high court, and then finally in Supreme Court it was decided. And this becomes very important. Now, this case is an example to what all I have been speaking in the past. Now, let's say what Ibrahim Uddin actually pleaded when he filed this suit in his plaint. So the very first averment which he made, that this original land belonged to the Maratha government or the Scindias of Gwalior, and their ancestors were pretty close to the then Maratha government, and this piece of land was granted to them under a settlement of 1800. Something very good if this owner was actually holding on to something like this. Subsequently, there was a partition in the property in 1819, which was also brought on record by the plaintiff. So this registered partnership deed of 1819, which must have been in Urdu, now clearly was neither exhibited nor proved nor marked, because it does not mention in the Supreme Court order. Further on, the plaintiff goes on to state in his plaint that Shrimati Hasina Begum and Safruddin became the absolute owner of the land of this 25 bighas after the death of their mother, called Shrimati Hasina Begum. Now, what is the main pleading in the suit? What the Honorable Supreme Court mentioned in its order. What does he plead? He clearly revealed that the land in dispute belonged to Hafiz Ahmad Baksh and Hafiz Karim Baksh, who were the ancestors of the plaintiff, and they were the owners of the same in the year 1800. The property then was partitioned between the so-and-so people in 1819, and the succession of the property was through a various document of Hafiz Karim Baksh and Hafiz Muhammad Baksh. The plaintiff claims from there, similarly what I just said, Hasina Begum, wife of Safruddin and daughter of Shri Hasim Ali. He had inherited the suit property, being a lone heir of Shri Hafiz Ahmad Baksh after the death of their mother, Shrimati Hasina Begum. Now, what was not pleaded by the plaintiff and what was pointed out by the Supreme Court in this case, the plaintiff has nowhere pleaded in this suit that this property flew into him through a will. So, neither he pleaded this, neither did he ask for an amendment of plaint when finally this document of will came in his hand. So, we will talk about this in a later part of the consideration. So, the land was never sold, alienated since 1800 and to date 1995. It was either transferred or gifted to any person in the plaintiff other than the ancestor. He further goes on to say that this land was rented to the state government of Agra, and a rent deed was signed on rupees 22 per month. When was it done? How it was done? There is nothing to prove on records. And the cause of action which rose as per the lower court was when the plaintiff, the government actually started proving its ownership about the property, and that's where the government actually decided कि should the property be taken over or should it be given back? So now here the defendants, the Union of India is pleading, and it's clearly saying that the ownership of the plaintiff is not there. The land belongs to Ministry of Defence, and this land was leased to various people on a time-to-time basis. Now, since the leases have not been renewed and these occupants are unauthorized occupants, so the estate court has even passed an order against eviction of these. So what is now the trial court framing is some 8 issues. Now the observations of the trial court is that the pedigree produced by the plaintiff along with the plaint was not successfully proved. The plaintiff could not prove any kind of grant by Maratha or his ancestors and grandfathers in 1800. The plaintiff failed to prove the partition also of 1819. The lease deed alleged to have been executed in favor of MEO or Union of India, the appellant was unable to prove that also. In view of the above, the suit was dismissed vide a judgment so and so 1998. Definitely when the suit was dismissed at the lower stage, the plaintiff went in for an appeal in session court, and when he filed that appeal, he simultaneously moved an application under Order 41 Rule 27 for additional evidence. And what was that additional evidence? What I just mentioned above, what the Supreme Court had said, that there was a will of 1929 which, as per the will, the property has been inherited by plaintiff, Mr. Uddin. So this application was allowed by the first appellate session court. Now the appellate court very clearly, when was disagreeing, it came to the conclusion that the Maratha government had made the gift of land in favor of plaintiff's forefather, which was subsequently partitioned. So they overturned the lower court's judgment. The registered partnership deed stood duly proved and it was a proof to the title. The plaintiff, respondent number 1, made an application for inspection of the records before the officers of the defendants, but on pursual the record was not permitted. So there are various kind of happenings which the session court, as per the my lord, overturned the first lower court's order. So the defendant even goes on to prove that under the Evidence Act 114G, the Union of India was unable to produce any such document to prove their ownership. So an adverse inference could be taken, drawn under the Evidence Act, that the property belonged to the plaintiff. And the will finally, which was taken under additional evidence, was allowed. So the session court gave the order in favor of the plaintiff, who is now an applicant. So two things were allowed in this session court. One, additional evidence was allowed. Second, under the Evidence Act 114, the party was allowed to lead, was taken an inference on that Union of India could not produce something. Now Union of India went under an RSA appeal in the High Court. Now there was no documentary proof what the RSA or the Honorable Court speaks. Trustworthy oral evidence that the suit property had been given to the forefathers of the plaintiff respondents, that as such that the Maratha government in 1800 gave it to them. The same remained for the factual about the partition of 1819. There is nothing to be proved on it. The first appellate court had no occasion to decide the application under Order 41 Rule 27. Moreover, there has been no reference to the will in the plaint at the first appeal, thus it could not be taken on record for want of pleading in this respect. Further, taking the will on record did not mean that either the will or its content stood proved. So on these grounds, the Union of India moved to the High Court. Now, it's very important. Additional evidence cannot be taken by first appeal before deciding the main appeal, is what the Council of Union of India speaking in his RSA. Now, he is even very clearly pleading that since there was no pleading, no evidence could have been led regarding the will, and at that also at a later stage of the first appellate. Now, the High Court, after admitting the RSA, framed four substantial questions of law, and these were very clear. Whether the judgment degree passed by the lower appellate court is vitiated in law inasmuch as the land in dispute, which was recorded as B4 land under Rule 6 of the CLA rules in 1937, was wrongly and illegally discarded on the grounds of secondary evidence in the presence of the original registered maintained by MEO. A very, very important substantial question of law. Whether the certified copies of the relevant registered maintained by the cantonment authorities under the Act are admissible in evidence, the appellate court erred in law in discarding the same evidence. So, the degree of the suit of the plaintiff is on a false pretext, and there is no document to prove or has been filed either by the defendant. Whether the appellate court did not consider this aspect at all about the suit of declaration without possession is not maintainable under the provisions of the Specific Relief Act. This is a very important section. That is why I say, when we have to make a plaint, we have to read the entire judicial or the various acts, starting from Specific Relief Act, General Clauses Act, Evidence Act, Limitation Act, TPA Act, Registration Act, Grant Act. So there are so many acts which have to be read into once we are proving that this land belongs to us. Now, whether the lower appellate court was committed in illegality while accepting the will dated 1992, filed on 1999 without proof of it in the plaintiff. Now, friends, while deciding the RSA, the High Court overlooked all the substantial questions of law and clearly gave the judgment on the pretext of the first appellate court, and finally the Union of India filed an SLP in the Supreme Court. Now, the whole case when came to Supreme Court, it basically relied on two things. One is presumption, the other was presumption under the Evidence Act 114G and additional evidence taken under Order 41 Rule 27. So, what does the court say? That it is the duty of the party to lead the best evidence in his possession, which could throw light on the issue in controversy, and in case such material evidence is withheld, the court may draw adverse inference under section so and so 114G, notwithstanding that the onus of proof did not lie on such party and it was not called upon to produce the said evidence. So 114G has a very specific doing. Now, the court is mentioning very clearly how this application under Order 41 Rule 27 was moved, how and when is to be considered. How and when. So, the observations made by the Honorable Court in para 15 was that Order 11 CPC contains certain provisions with the object to save expenses of obtaining information to material facts and obtaining admissions of any fact which he has to prove on an issue. Therefore, a party has the right to submit interrogatories relating to the same matter in issue. Now, here the Supreme Court is defining the word matter. The expression matter means a question or issue in dispute in the action and not the things about which the dispute arises. So, it is weighing the difference. You may bring in 110 things, you may bring in thousands of evidence, But does that relate or does that matter to the pleadings what you have done? The object of introducing such provision is to secure all material documents and to put an end to protectorate inquiry with respect to documents material in possession of other party. And here it is the Union of India. In such a fact situation, no adverse inference can be drawn against a party for non-production of such documents unless notice was served, procedure was followed under the CPC. That is why I say, please, now under order 11 rule 14, the court is competent to direct any party to produce the document asked by other party which is in his possession or power and relating to the material of question in the suit. The similar order 11 rule 15 provides inspections of document. Rule 18 provides empowers the court to issue order for inspection. Rule 21 clearly provides very stringent consequences for non-production of the documents or compliance of the orders. So what is the court speaking? He shall, if he is a plaintiff, be liable to have his suit dismissed for want of prosecution, and if he is a defendant, to have his defense, if any, struck out and to be placed in the same position as if he had not defended, and the party interrogatory or seeking discovery or inspection may appeal to the court for an order to that effect. Thus, in view of the above, the suit may be dismissed for non-compliance of the aforesaid orders by the plaintiff, and the plaintiff shall also be precluded from bringing a fresh suit on the same cause of action. Similarly, defense of the defendant may be struck off for non-compliance. So, the rule is very clearly balancing both the plaintiff as well as the defendant. So, this is a very important finding in this case which the Honorable Supreme Court gave, which I have been asking all owners to build your own evidences. I hope we will understand the same, and with such scathing observations given by the Honorable Supreme Court in this para. In para 16, the view of the law is an issue can be summarized to the effect that the issue of drawing adverse inference is required to be decided by the court, taking into consideration the pleadings of the parties, and by deciding whether any document / evidence withheld by either party has any relevance at all, or omission of its production would directly establish the case of the other side. Could be plaintiff, could be defendant. A court cannot lose sight of the fact that the burden of proof is on the party which makes a factual averment. So that is why I say don't try and become plaintiffs, because the minute we are a plaintiff, everything we will plead and we will have to prove. The court has to consider further as to whether the other side could file interrogatories or apply for inspection and production of document, etc. under Rule 11. Conduct and diligence of other parties also of very paramount importance. So, presumption or adverse inference of non-production of evidence is always optional and a relevant factor to be considered in the background of facts involved in the case. So, friends, we have to understand why is the court or why is the system being so nitty-gritty about this will and the pleadings. It is a lesson for us. Let's presume, let's for 1 minute think, yes, the courts are going towards the Union of India. No, they are not. They are only asking that, did you plead? Did you lead evidence? Did you prove your document? Did you ask for, under Rule 11, any of these things which were allowed? Did you file interrogatories? So, these all facts, we cannot leave any door open for the government. We cannot leave any hole in our plaint or in our pleadings or in our evidence. So, existence of production of such documents on some reasonable grounds is to be worked out. So, then only the pros and cons must be examined before taking adverse inference. Such presumption is permissible if the other larger evidence is shown to the contrary. Plaintiff had moved an application on inspection. The court was admitting into it. It was allowed, but it did not do the inspection, it says. Why didn't he do it? Because one has to understand what was he trying to inspect. That inspection letter is needed. So somebody in Agra should dig into that inspection letter. Now the court says under section 58 of the Evidence Act that if the defender does not produce any paper in rebuttal, then it means that he admitted the paper produced by the plaintiff. There is no need of proving the same. So where is the application where he is seeking inspection and production of document? The question does not arise as whether not filing of a document in rebuttal, the document amounts to an admission, and whether the provisions of 58 are attracted. Order 12 CPC, now the court clearly reads on admission. Now this is the section which, when we've all given admission deeds, admission of documents and judgments are attracted. Rule 1 provides something, Rule 2 deals with the notice to admit documents, Rule 2A provides that documents could be deemed to have been admitted if not denied. Admission, it says, is the best piece of substantive evidence that an opposite party can rely upon. Though not conclusive, is decisive of the matter unless successfully withdrawn or proved erroneous. Admission may in certain cases operate as an estoppel. This is where I say 1938 or 25 onwards, everybody in these cantonments, their predecessors have given admission deeds for mutation. In view of the law on the admission can be summarized to the effect that admission made by a party, though not conclusive, is a decisive factor in the case unless the other party successfully withdraws the same or proves it erroneous. Even if the admission is not conclusive, it may operate as an estoppel. Law requires an opportunity to given person who had made an admission under cross-examination to tender his explanation and clarify the point of question of admission. Failure of the party to prove its defense does not amount to the admission, nor it can reverse or discharge the burden of proof of the plaintiff. In fact, admission by a party may be oral or in writing. Admission is governed under section 17 to 31 of the Evidence Act. On such admissions can be tendered and accepted by substantive evidence. So my Lord has very clearly shown us and explained us that these two sections of the CP and Evidence Act prove our admission. So now the Lord says that the application under 41 Rule 27 led by through the Supreme Court. What does it say? The general principle is that the appellate court should not travel outside the records of the lower court. Outside the record means outside the pleading, evidence, documents, exhibits, marks, defendant's pleading, written statements, and finally. So you cannot go outside that and pick up something additional evidence. So this is how it is. So my Lord is stating that it was for the plaintiff to decide in para 29 in its averments the party for or his inability to understand the legal issue involved or the wrong advice of a pleader or the negligence of a pleader, or that the party did not realize the importance of a document, does not constitute a substantial cause within the meaning of this rule. I don't need to speak more than. The Honorable Court has very clearly said if there has been a wrong advice from the pleader or a negligence at the part of the pleader, it does not give you any relief. So, the words for any other substantial cause must be read with the word require in the beginning of the sentence so that the that it is only where for any other substantial cause the appellate court requires additional evidence, that this rule will apply, for example, when evidence has to be taken by the lower court so imperfectly that the appellate court cannot pass a satisfactory judgment. So my lords are very explicit in this, and they are clearly in para 33 is settling the proposition that only administrative orders but also judicial orders must be supported by reasons recorded in it. So if any application, if any order has to be passed, whether it is an intercalatory order or it is a regular order, it has to be very clear. But thus, while deciding an issue, the court is bound to give reasons for its conclusion. It is the duty and the obligations on the part of the court to record reasons while disposing of the case. The hallmark of order and exercise of judicial power by a judicial forum is for the forum to disclose its reasons by itself. And giving of reasons has always been insisted upon as one of the fundamentals of sound administration of the justice. Delivery system to make it known that there had been proper and due application of mind to the issue before the court, and also as an essential requirement is of the principle of natural justice. So there can be no order like this. It has to be a speaking order. The court has insisted the hallmark order of exercise of judicial power forum is for the forum to disclose its reasons by itself, and giving reasons has always been insisted upon as the fundamental of sound administrations. So this is how it is. The reasons is the heartbeat of every conclusion. Reasoning. The absence of reasons render an order indefensible, unsustainable, particularly when the order is subjected to further challenge before the higher forum. Recording of reasons is principle of natural justice, and every judicial order must be supported by reasons recorded in writing. It ensures transparency and fairness in decision making. So the main question now comes is the suit for declaration under the Specific Relief Act 1963, Section 34. What does that say? The section clearly says, if you are not in possession, you cannot seek suit for declaration, provided you are able to seek further relief than a mere declaration of title. Omit to do so. So the plaintiff made a mistake, or the pleader, that he only claimed suit for declaration, but he did not seek other reliefs with the suit for declaration, which he should have, because this law permits him and even demits him. So in view of the above, the law is crystal clear that it is not permissible to claim the relief of declaration without seeking consequential relief. In the instant case, suit for declaration of title of ownership had been filed through the plaintiff. Number one was admitted not in possession of the suit property. Thus, the suit property was barred under Section 34. Now, this is where I tell people, when we pick up our plaints which are made by our young advocates and very learned lower court advocates, one has to understand the acumen when you move into the constitutional courts like the High Court or the Supreme Court. It is the law which is discussed there and not the evidence or the plaint or the written submissions. It is how the law interprets those pleadings. The lower court, the advocate there would only plead the facts what is written in the plaint order either. But we can plead everything if we want. There is nothing as such which is called discriminative. So the High Court though framed the substantial questions of law point, but for unknown reason did not consider and made an observation on it as per section 100 of the CPC. So friends, please, I've been stating throughout, these things are very important in your plaint. So very clearly my lord has said no pleading, no evidence. A decision of case cannot be based on grounds outside the pleadings of the parties. No evidence is permissible to be taken on record in the absence of pleading in the respect. No party can be permitted to travel beyond the pleadings, and that all necessary material facts should be pleaded by the party in support of the case set up by it. So here the court says, now the lower court advocate or the lower court judges would feel a plaint which runs into 100 or 200 pages, 1,000 evidence pages, because cantonment subject starts from 1793. And if we land up from 1925 or 1960, we will never win. So the Supreme Court has completely trashed the rent deed produced by the plaintiff by stating it has not been proved, and there is no mention in the suit property or date of the same document. Instead, that the Union of India produced a GLR. Now look at this. So Union of India is depending the Journal Land Register maintained under the rules of the Cantonment Act 1924. It is a public document, and under section 65, 74 of the Evidence Act, it is a settled proposition that GLR is a conclusive evidence. So how do you counter this? That's the question. Finally, the Lords allowed the appeal of Union of India on such counts. It's clearly summing up its decision. The first appellate court as well as the High Court committed a grave error in shifting the burden of proof from plaintiff to defendant, though it could have been exclusively the plaintiff to prove his case. We now have to realize these facts. There is nothing on record to prove the Maratha government had given a gift or a grant to the plaintiff in 1800. So it is the plaintiff who has miserably failed to prove his evidence. Neither he could prove his partition of 1819, which he brought on record. So the presumption under section 90 of the Evidence Act in respect to 30 years and old documents coming from proper custody relates to the signature, execution and identification of the document. And then the genuineness of the document does not give rise to a presumption or correctness of every statement contained. And this is where the GLR under section 90 is being proved. So the contents of the will are neither being proved, neither are being shown. There is nothing. Neither the rent note which was produced by the plaintiff below does not prove it. It goes around to say it is a vague document. It is definitely in favor. How it was executed, how this was done, thumb impression, nobody has been brought on record. So you have to take these cases very seriously. There has been a will in existence, now the court says, but it was not pleaded during the pleading. Why it was not done? The reasonings are given in the application that the document was not there in the hands of the plaintiff in 1995. He misplaced it and later he found it. So he again somewhere, it is such an important document and it was not pleaded. So the court is creating a suspicion on it, and it is rightly doing that. So pleadings and many of our such cases, if we see, which I have just spoken on, we lose only on these grounds because we don't plead, we don't produce evidence, we don't call for evidence. Sorry to use this word, when I filed interrogatories in my case, I was surprised that in Ambala court, one of the senior most advocate told me that for the last 40 years, this is in 2015, so last 40 years means in 1970 or 80, he has not seen anybody filing interrogatories. So how does section 68 of the Evidence Act in accordance with law would help us? So there are so many things what the Honorable Court has said. It says very clearly you cannot travel beyond pleadings. So no party can lead evidence if there is no pleading. No issue, no pleading, no pleading, no issue, no evidence. It's all correlated. So friends, please understand this case. When it came in my hand somewhere in 2016 or so, I was amazed, and there I was doing my law at that time. So the court clearly dismisses Order 41, Rule 27, that the evidence was not to be brought in because there was no pleading, documents could not have been taken, and the High Court and the Appellate Court completely ignored the GLR, which was a copy certified, so grave errors. And then Section 34 of the Specific Relief Act very clearly states that a suit for declaration cannot be filed. So with these kind of findings and rebuttals regarding the will, and so court has finally given a conclusion that this case, when was being drafted in 1995 or further on, he did not file an amendment of plaint, he did not file any applications for documents. So like him, like Mr. Ibuddin, we will all lose. And please, in the past there are so many advocates, I wouldn't call them advocates, bungalow owners who have become consultants from Jhansi, from Sikandrabad. People talk to me from Allahabad. Varanasi is an example setter. I yet remember that man is no more now. He was an advocate either. Please, friends, please make sure what you plead, because if you are not pleading, you will not be able to lead evidence. Thank you. Good day.